Welcome to The Explainer. Today, we're diving into the world of civil lawsuits. We're going to peel back the layers and give you a clear step-by-step roadmap of the entire process, from that very first document all the way to the final decision. We hear that phrase all the time, right? In movies, on TV, maybe even in real life. But what does it actually mean? What gears start turning in the legal system when someone says those famous words? Well, that's exactly what we're about to find out. Here's our game plan. We're breaking this journey down into 5 key stages. First, how a lawsuit is born. Then, how the stage is set for the fight. Next, the all-important gathering of evidence. After that, the final verdict. And last, how that ruling actually gets enforced. Okay, let's start at square one. Every single legal journey has an official starting line, a specific document that gets the whole ball rolling. And that document is called the plaint. Now, this isn't just some angry letter. It's a formal, structured legal paper that has to do 3 really specific things. It has to name who's suing who, it has to tell the story of what happened, and it has to state exactly what the person suing wants the court to do about it. And with that plaint, our 2 key players are officially on the board. You've got the plaintiff. That's the person who fires the starting gun on the lawsuit. And then you have the defendant. That's the person on the other side who now has to respond. So the first move has been made. But a lawsuit isn't a monologue, right? It's a dialogue. The court's next job is to make sure the other side gets to speak. This is how the stage gets set for the legal battle ahead. The court does this by issuing a summons. This is an official notice delivered right to the defendant. It pretty much says, hey, you're being sued. Here's why, and you are now legally required to show up and give your side of the story. This makes sure the whole process is out in the open. And in response to that summons, the defendant files their big document, the written statement. This is their chance to reply, point by point, to everything in the plaint. They'll go through the claims, admit to some things, deny others, and start building the foundation of their defense. So here you have it in a nutshell. On one side, you've got the plaintiff, laying out the problem. On the other, the written statement, pushing back with a defense. With these 2 documents, the battle lines are officially drawn. And this, right here, is the million-dollar question for any court. You've got 2 completely different versions of events. So how does the system possibly sort through it all to find out what actually happened? Well, that leads us right into the heart of the journey, gathering evidence. This is the part where we move past the accusations and start looking for proof. It's all about finding the factual and legal truth. Now, a trial isn't just a chaotic, free-for-all argument. To keep things from going off the rails, the judge first frames the issues. They look at both the plaint and the written statement and pinpoint the exact things the 2 sides disagree on. This is so crucial for keeping the trial focused and efficient. And get this, the judge isn't just a passive umpire sitting on the sidelines. They can actually jump in and question both the plaintiff and the defendant directly. The whole point is to cut through the legal speak and get to the core of the disagreement. Sometimes, this can even spark an early settlement, which, by the way, is how the vast majority of these cases actually end. Then we get to the main event, the evidence stage. It's a structured back and forth. The plaintiff goes first, presenting their documents and witnesses to try and prove their case. Then the defendant gets their turn to do the same. Witnesses are called up, they're questioned, and then comes the really critical part. They're cross-examined by the other side to test just how solid their story is. All right, all the evidence has been presented. The witnesses have all testified. We are now at the climax of our journey. It's time for both sides to make their final pitch, and for the court to finally make a call. This all happens during the final arguments. This is the last chance for the lawyers to stand up and connect all the dots for the judge. They'll wrap up all the evidence they presented and argue why the law, when you apply it to these facts, is on their side. After that, the judge issues 2 separate but connected things. First is the judgment. You can think of this as the why. It's the judge's detailed written explanation for their decision. Then comes the decree. This is the what, the short, formal, legally binding order that says who won, who lost, and what has to happen next. But hold on. What happens if the losing side just ignores the decree? A victory on paper is pretty meaningless if nothing actually happens. And that brings us to our final and maybe most important stage. This is called the execution of the decree. If the losing party doesn't cooperate, the winner can go back to the court and ask it to enforce its own order. This is the step that gives the whole process its teeth. It's what turns a piece of paper into a real-world consequence. So let's do a quick recap of the entire journey. It starts with the plaintiff's plaint. The defendant hits back with a written statement. Then comes the fact-finding with all the evidence. The court makes a decision with a judgment and a decree. And finally, you get enforcement through the execution of that decree. You see? It's a logical path from conflict all the way to resolution. So now that we've seen the entire map laid out, from that first filing to the final enforcement, it makes you think, doesn't it? What does this incredibly structured, step-by-step process really tell us about our whole system's search for justice? It's really an attempt to bring order to chaos and a framework for fairness in the face of conflict. Thanks for watching.